1, 2, and 3.
May I just mention a matter with your Lordship's leave? It's a clarification of your Lordship's order. Just one word I'll have to keep added. Your Lordship has said authorities. I have made a clarification as to which authority. We'll made it come in the list on Wednesday, my Lord. I've already filed it.
In that matter,
this is the Shillong cantonment matter.
Oh, I see.
Mr.
Not that.
Mozika is on the other side. No, in that, it's a new matter so far I'm concerned. Very short, I'll serve him. I'm telling him here and now, the authority which is, your Lordship has said the authorities may consider the objection. So Mr. Mozika in his affidavit has set out the name of the relevant authority. I just want that to be incorporated in the order. There should be no problem with it.
This matter is fixed on which days? Today?
It's a new application in the matter. It's for the order, clarification of the order. Matter is disposed of. It's for the...
This liquor matter is fixed for today and tomorrow.
Yes. No, liquor matter is fixed the whole week according to me, madam.
You want to do it on Wednesday? No.
I want to do this matter on Wednesday.
All right. Let it be listed.
I am blushed.
As an application?
I am blushed.
Item number 1, 2, and 3.
Legal position. Do you want me to answer this? My Lord, two closing submissions, my Lord.
Yes.
First, my Lord, one is in the nature of a reiteration, but nevertheless in 5 to 10 minutes, if I may make that good, my Lord. Our main submission on this issue, and this is a matter of very fundamental importance, is that, you didn't get that concession? That? Yes. Is that a policy has to be judged on the grounds of reasonableness and nexus to the statute or whatever the public purpose may be. I believe while making his submission, Mr. Shah also acknowledged that while commercial considerations may be relevant to some extent, margin, one bite of the cherry or 2 bites of the cherry or whatever, ultimately a policy cannot be struck down on that sort of ground. A policy has to be struck down on fundamental grounds of
again, unconstitutional or illegal or grossly arbitrary, discriminatory.
So the first question, your Lordship, I would reiterate, and this is very important when your Lordship is coming to a decision, the modality should be, the order should be, is the policy liable to be struck down on any of the grounds known to law or not? That's number one. If it is to be, my contention before my Lord is very well settled, if the policy is otherwise fair and reasonable and inconsistent with public policy, then, if your Lordship holds that, then the second question of whether some economic damage is done to the petitioner becomes much less relevant. Kindly appreciate this. This is very important and fundamental to my argument. It is not possible to say in law that, yes, you are right, that increase of revenue is a good public policy. Improving the number of brands and increasing the sales is a good public policy. There is good reason from a policy point of view for the central warehousing, for the CBW to exist. But however, I hold that although the policy may be otherwise just and reasonable, because the supplier is having to pay an extra commission of some huge percentage, therefore the policy to be struck down. This, with respect, is not the law. It will be the law in a very rare case where it amounts to total expropriation. Your Lordship knows the nationalization cases. Entire coal mine taken over. Supreme Court says you have to give them something. Schedule 1, Schedule 2. You take over the entire business, nationalize everything. Then in a case of complete expropriation, then maybe some compensation or some situation like that may occur. It is nobody's case that this is a complete expropriation case. Today, if all the bonded warehouses had been abolished, suppose the policy today is, I abolish all bonded warehouses in the state and I'm having only one CBW. The bonded warehouses come and say, my entire business is stopped, I'm entitled to compensation. Possible. I'm giving also possible areas where commercial loss may be a relevant factor. Very, very extreme cases. In no case, your Lordship will find, cited by my learned friends or on research, that some 10% extra cost or 20% extra cost is sufficient to say this is expropriation, strike down the policy. You can't strike down a reasonable policy of central warehouse on the ground that I'm having to pay more. If you're having to pay more, that is the cost of the policy. That happens. That's my first and preliminary argument. Lordship, this is the basic argument.
First of all, policy is something specialized, in a specialized field as perceived by the government.
Right.
And it is formulated by an expert in the field.
Yes.
The court is not an expert.
That's right.
All right. And if it is like that Benthamian theory, greatest good of the greatest number, if the court sees that the policy is doing good to the public at large,
right,
then if individual, if the loss of...
I agree. If some individual unfortunately has to suffer the loss, that must be the price that has to be paid in the system. That's the basic principle.
The court will only interfere if it finds that something is very unconstitutional, illegal, or absolutely arbitrary, discriminatory, etc.
Therefore, my very respectful submission is that whatever queries have been made by this court, when I say this court, I don't mean only this bench, this court at various stages as to what can be done about the commission, with great respect, is missing the legal challenge altogether. Why Mr. Shah took so much time on expresso unius? Because he knew that if section 19 falls, then the policy falls. That country liquor and all that. If there is no power in the statute, then the policy falls. That is the correct, if I may say, legal approach. He may not be right on the fact of that section 19, but yes, he is right on the way in which to challenge a policy. If a policy is contrary to the statute, the policy will fall. Similarly, private monopoly point, which I have shown to your Lord, is perfectly permissible. If there is a general principle of law that no private organization can be given this, anything to do with liquor, which is argued, then the policy will fall. These are broad constitutional challenges which your Lordship will consider. I've answered them, I'm not going to repeat. But your Lordship would not hold that everything is in favor of the government, the policy is reasonable, but I find, instead of one bite of the cherry, now two bites of the cherry, poor fellow, he's suffering and he has to pay more because he's not getting any service.
I was also doing a little bit of reading on this.
Yes.
As far as monopoly is concerned, if it is of the whole trade, all the sectors and total control, then it is monopoly. But if it is only of a part of it,
my lord,
this central bonded warehouse only regulates a part of it.
That's right.
It cannot be called a monopoly.
That's right. Lordship, absolutely right. Because the streaming is coming through the bonded warehouses and it is ultimately...
Even if you assume that the government cannot create a monopoly in favor of a private party, let us assume.
My lord.
Even then, this does not appear to be a monopoly because the whole liquor trade is not entrusted.
That's right. I'm grateful. The CBW is a creature of what are the indents are given by the separate bonded warehouses.
It's only one segment of it.
It's one segment in the chain. Your Lordship is perfectly right. I'm very grateful. It is not the controlling. Unlike the case of this Uttarakhand case where there was one board, that board had full control. It will give whatever supplies it wants. It will take whatever order it wants. Complete monopoly. Even that was not struck down. But in this case, the CBW is only to receive orders from one chain and take it from another chain. It is a intermediary, so to speak.
But now tell us, Mr. Banerjee, how much commission central warehouse will get and how much will the lay bonded warehouse?
Lord, may I? So far the state is concerned, whatever your Lordship feels, we have nothing to say.
But under your notification?
Under our notification, it is not fixed at all. Bonded warehouse is fixed at 8% minimum.
Okay.
By this new policy, earlier there was no minimum, so they may have got 2, 3 also. Now under the new policy, bonded warehouse gets 8%. Lordship kindly makes a note. Minimum. So supplier has to give the bonded warehouse, Mr. Shah's client has to give the bonded warehouse 8% in his chain. What he has to give CBW is to be negotiated between CBW and the supplier. We have nothing to do with it at all. If your Lordship feels some amount is reasonable, but it is a matter between CBW and the supplier. It's between two private parties. Kindly appreciate. Purely between two private parties. So whether your Lordships are in a position to lay down any reasonable commission.
Will it be the supplier or it will flow the other way?
No, ultimate.
Say the retailer gets 100 rupees out of a bottle. Now he routes that money up to the supplier to pay the supplier, and in the chain.
Let's put it this way: the price is fixed at the end.
Yes.
So working backwards, it will be working its way back to what the supplier will sell it at. So in that 100 rupees, if it reaches the
say
customer,
a retailer in Shillong gets 100 rupees for a bottle. Now he has to route that to the supplier ultimately, and in
that 100 rupees, say the retailer will take 20 rupees. I'm giving an example,
and send it to the bonded warehouse. They will retain 8 and send to the supplier.
So somewhere in that chain, ultimately the figure always comes out of the customer. Your lordship is right, because the total amount will be paid by the customer. In that total amount, the profit of the supplier will contract or expand by the extent of that commission to the CBW.
Yes.
So that is where it will contract expand.
In one correspondence, it is written that the taxes are paid.
The taxes are paid directly. Taxes are fixed. Taxes are not going to vary. Taxes are paid directly by the CBW and recovered ultimately, right?
Online.
Yes.
It is paid online, and
that's a fixed constant. So that lordship is not concerned with that constant.
There is no revenue leak.
No. That is what my learned friend said. We said there is a revenue leak still
because of clandestine.
Yes, clandestine transaction. That's the revenue leak.
Yes.
So it is a question ultimately of the commission which the central bonded warehouse will be getting. How much will he get from the suppliers? Mr. Shah's contention was that it is going up to 17, 18, 20%, etc., etc. We have said it is not that. We have shown some figures. I'm not going to emphasize that because there may be some other producers where they're giving 8, 10%. My point is, it's very difficultly for your lordship to fix that commission. But as the state is concerned, we have nothing to say. Because whatever commission is fixed is not going to concern us. It is going to concern the CBW and the supplier, both of whom are here and will make their submissions on that. So if your lordship thinks something is fair, we have got nothing to say. That's another matter. But I would.
You also argued, Mr. Banerjee, that you will not look at the commission, you will look at the profit.
That's right.
Now, if there is a marginal fall in profit also, it does not matter.
No.
As far as the policy is concerned.
That's right.
That I have taken note of.
My lord, I don't need to show the design and all that. Just give me that paper. My lord, in light of your lordship's observations only, you have not stamped the others. Yes. May I just hand over this with your lordship's leave? I'm giving my learned friend. This is officially verified from the records of the customs. Just one thing I'd like to show you. This is now, since your lordship, I was going to argue on that economic loss and all that. I'm not going to trouble your lordship because your lordship has already got that question. Kindly see this. Now, it's a new question which I'm raising before my lord. Kindly consider this also. This is not on law. I've made my submission on the law. Kindly see how the revenue 2021 is when the warehouse started. There is no stay. The warehouse has been functioning for 4 years. Kindly look at the figures from 2021 to 24-25. All these except number 3. Non-SY. 1, 2, 4, 5 and 6. Kindly see the revenue has gone up from 66,000, 95,000, 1,45,000, 2,85,000, 4,68,000. Does your lordship see that?
This is of the supplier or of the...
Yes, supplier. All brands of the supplier. Massive revenue increase. Because according to us, because I tell your lordship why. They may or may not agree. The fact is that because of the central bonded warehouse, they have said so in their affidavit and in their letters, the brand availability has gone up.
This figure is excise collection?
Yes. No, this is sale. Sale. Not excise collection. Number of bottles sold.
Number of bottles?
Yes.
Otherwise, 4,68,000.
No. Number of bottles. I'm sorry. Number of bottles. Cases. I'm sorry. I'm corrected, my lord, by the bonded warehouse. Cases. 12 bottles. One case, 12 bottles. Now let's take one example. My point, to illustrate my point. What was there before the bonded warehouse? Imperial Blue, 66,000 cases. Kindly see. First entry. Now it is 4,68,000. That is what? 7 times, 8 times. Similarly, the third one, fourth one, all of them have gone up multiple times. Now, just think about it. Kindly carefully think about it. Since your lordship is on equity aspect, which according to me, of course, is not really that important. Because of my policy of brands, because the CBW can give so many brands, every tiny little village and town in the whole of Meghalaya is now able to pick up entire range of brands. I'm informed that smallest of towns now have got a full range of all the brands because it is easy to get it from the CBW. Earlier, these brands were not possible because you needed the full truckload to come. I'm not repeating all that. But I'm showing you the result. Because of my policy, according to me, these sales have gone up 7 times. So when you are balancing your commission, what about the fact that you're earning 6 times more because of my policy? Because let's be very clear. The number of drinkers in Meghalaya can't go up 8 times in 5 years. Little difficult. Your marketing is prohibited by law. You can't advertise liquor. So what are the new factors which have increased your revenue by this massive 5-6 times? 6 times the population of Meghalaya has not gone up. 6 times the population of drinkers has not gone up. Marketing has not gone up. Only because of the availability of these brands, these revenues have gone up from 1,92,000 to 2. Everything more than 100%. So kindly consider, if your revenue has gone up so much because of my policy, then if you are paying 10% extra margin has to be balanced against what profit you are making. Your lordship will see those Uttaranchal cases.
Any fall in commission is made up by
the
turnover.
Yes, by the turnover. I am grateful.
By the size in turnover.
Size of the turnover. That is why they have not given your lordship the revenue figures in any of their brands. That has been given in the Uttaranchal case, that has been given in the Chhattisgarh case, that has not been given by them because they cannot show that the loss of revenue has happened. Because it has not happened. This is the reason. Now, if that is the case, then why would your lordship, ask myself, bother about the margin of commission? You are making so much extra profit because of the policy. So let's have a margin of commission maybe 40%. How does it matter? If you are making more money, then why should the margin be considered at all? That's the point I'm making. It's an additional point. Anything else? None? My lord, I don't think I have anything further to add. I'm grateful for a very patient hearing.
As many said, you also said that you don't shun government briefs. You are paid less, but you make up in the turnover.
that is when the turnover turns over, so to speak. Yes. Mr. Shah, I think, is enjoying this, my lord. I'm grateful to my lord.
No. Now, who will make submissions?
The state is there. The AG
was to address some arguments.
You start. Or you will start for the...
I think let the warehousing people say something, my lord. I think Mr. AG is there.
Yeah, am I audible, my lord?
Yes.
Let warehousing, my lord, commence the argument. I will join the argument after physically, my lord. Tomorrow after the argument.
You are mainly you are adopting Mr. Banerjee's submissions.
Yeah, I will be adopting, but supplementing some of the aspects, my lord. I need only 15-20 minutes, my lord, to supplement what Mr. Banerjee has extensively.
Tomorrow
then.
In
the meantime,
No, but let for the central.
Oh, warehousing. Yes.
Yes. Huh?
Advocate General will address one.
No. Who is appearing for the central warehouse? You?
I'm appearing the second matter. Against the bonded warehouse in the same CBW. I'll be arguing the second matter.
The first matter, second matter are similar.
Same matters, but one is by the ES5 and another is by the bonded warehouses of this state, Meghalaya. So there are two matters, my lord. The bonded warehouses say that we are eating upon their margins. No,
bonded warehouse means you are supporting Mr. Shah.
No, my lord, we are not. My lord, I am also for the CBW, but in the second matter, my lord, there are two writ petitions. My learned senior friend is appearing in the first matter as the respondent for respondent 3, and I am in the second matter, my lord, where the bonded warehouses have filed the second matter.
Central bonded warehouse has filed.
My lord, the bonded warehouses have also filed, which Mr. Paul is appearing.
Yes, he's supporting Mr. Shah.
He is supporting Mr. Shah, but on different counts altogether. They have got an additional argument, so I am going to meet that argument, my lord.
Mr. Paul was representing Mr. Central, the bonded warehouse. Mr. Paul was
So in the
representing
second
bonded
petition,
warehouse.
we are representing the bonded warehouse of the state lodge. So,
Yes, but your cause of action is common with the.
it's common, yes. Yeah.
Totally different entities.
What? Who are the different entities?
The first entities, my lord, kindly have the Mr. Shah's client are the manufacturers and the suppliers.
Yes.
The bonders.
Yes.
The bonded warehouses are just like us, my lord. They are now put under us, under the CBW.
That is all.
That is all.
The rest is the same.
The rest are
Argument-
arguments are almost the same.
Yes. You are also challenging the vires of the act, the rules.
I am not challenging, my lord. The bonded warehouses are challenging the
So you said you are representing the bonded warehouses.
My lord, he is representing the central bonded warehouse, which was
Then-
created subsequently, my lord.
My lord, I am in the second matter, I am saying, my lord. I'll be responding in the second matter.
My lord, if
That
I,
is-
may I have a minute? Let me clarify this value.
What he
Let me
said.
just clarify. There is one writ by Mr. Shah.
No, I know that there is a central bonded warehouse. Now there is
Now,
a move,
there are two other writs.
Move
One
to-
one
move-
is the bonded warehouse by Mr. Paul.
and now there is a move by the government to create more central warehouses.
That's right. So Mr. Paul has the first one is that Mr. Paul has supported Mr. Shah, also challenging the policy of CBW. That is
Yes.
Mr. Paul's petition.
Yes.
And there is a second one with Mr. Singh is appearing where the second bonded warehouse which has been created, that policy has been challenged by the first bonded warehouse CBW. He is referring to that one. So there are three in all.
First central challenged by the central bonded warehouse.
No, the CBW's existence is being challenged by the second central bonded warehouse. The creation of the second bonded warehouse is being challenged by the CBW.
Yes. So he is representing the CPW.
Yes, somebody is the CBW.
Why is
In
he
that,
saying bonded warehouse, warehouse?
he is representing the bonded warehouses. Mr. Paul.
The existing central bonded warehouse does not want others to enter the field as a central bonded
That is
warehouse.
Mr. Singh's writ. That is his writ.
And learned Deputy Solicitor General?
There is a second writ petition by Association of Meghalaya Bonded Warehouse.
That Mr. Paul's
That is
writ.
writ petition number 234. But I am respondent there as a CBW. There is a second matter also, my lord.
Which is your writ?
Association of Meghalaya Bonded Warehouse.
Which is your writ?
But my writ, I'm in writ petition number 430. That is no.
Forget the number. What is the ground?
My
Who has made it? It is made by the
Yes,
central.
but it is by us.
Yes.
Against the creation of the second.
Yes, say so. You took 10 minutes time to to identify your client.
I am so sorry.
Yes, Mr. Muzika.
My lord, I'm appealing for CBW.
Which one? The existing one or the subsequent?
To the policy, there are two challenges, as Mr. Bani said. One by Mr. Shah's client, my lord, and one
That I've got.
these two matters, my lord. The third matter where a challenge has been made to the
You're opposing that.
my lord. So more or less, I'll be adopting Mr. Banerjee's submission, my lord. The few facts I'll bring to your lordship's notice, my lord.
You can
Yes.
My matter is directed to be heard after these two matters.
forget about the direction. Can you start or not today? Today there's some time.
I was to. I kindly have it tomorrow then.
Yes. Then tomorrow who will make submissions?
My learner.
Learned AG also is making submission.
So then,
I'll make-
let it follow the sequence.
My lord.
After Mr. Banerjee let learned AG make his submission.
Well.
So that part is closed. Thereafter, you and Mr. Singh fight it out,
Yes,
and the reply will be given by Mr. Shah.
my lord.
Yes.
All right, tomorrow.
Yes.
But Mr. Banerjee, you incorporate this in an affidavit.
Yes,
Otherwise, it is difficult.
I should have done that. I will do. Great. Your Lordship has another matter, I believe.
Yes, please.
Item number 4 and 5.
Amartya, you're not in this matter. Can you organize the... Or equity judgment.
May it please your lordship. My lord, your lordship had permitted me to place the judgments, my lord. I'll just place one by one. But the one judgment I have already placed that your lordship has noted, that is Datta Associates 1997 1 SCC, my lord. I am not repeating on that.
Yes.
The next judgment, my lord, that I will place.
And you file short notes?
No, my lord.
Short notes annexing all the judgment. That will be helpful for the court as an annexure.
My lord, that I'll do. But if your lordship, I'm just to elaborate the points.
No, you will elaborate the points. That is ultimate at the end. If it is possible, otherwise I have taken notes. There will be no problem.
No, my lord, the judgments if I'm to place now or along with the notes, my lord.
No, now. Otherwise, how will the other side know?
Yeah, that's why, my lord. That's
yes.
Now, the next judgment that I am placing is, my lord, reported in 2021 SCC online. Copy will down. Excellence. 2021 SCC online, Delhi. Well, I'll be relying on the paragraphs 44, 47, these two paragraphs. Paragraph 44 will be additional charge नहीं होगा. Paragraph 44, my lord. In tender matters.
Yes.
Well, in tender matters, the tender inviting authority should not have a myopic view. Its objective should be to encourage maximum participation in a fair manner and not to stump the bidders with unclear, ambiguous terms. If the tender issuing authority is stumping the bidder by confusing them or not resolving their doubts, then the act of the tendering authority would be antithesis to the very idea of the tender, which is to encourage maximum public participation and not to oust a bidder by devious means. We are aware that the tendering authority is considered the best authority to interpret the tender document, but when the plain and express meaning of the words used in the tender specifications and conditions is clear, then there is no room for interpretation by going into the mind of the author of the tender to find out what its intention was. Why I am referring to this, my lord, this paragraph, my lord, my submission has been that in assessing my bid, my lord, which is marginally higher by 1 rupee, my lord, they have taken a very, very technical view of the matter. Instead of, my lord, encouraging a free competition between the all of the tenderers, my lord, where all stand on the same footing, 7 except this difference of 1, they should have also allowed my tender to be taken into consideration, or asked me to give a price to match the figure. That they have not done.
Called you for the settlement process.
Settlement process. Because they have taken a very myopic view of the matter, that since I am higher by just 1 rupee, so they have outright rejected it. And they have said that they will go with the other bidders in the fray. So on that point, my lord, I am relying on this.
Mr. Dattu, you consider this. The tender specified the minimum price.
Yes.
And a reserve price.
Yes.
All right, which all of them quoted. 1, 2, 3, 4. Now, that is stipulated in the tender
itself.
terms.
Yes.
Now, during this settlement, could the tender committee, dip below that figure?
No, they have not gone below that, my lord.
No, suppose there 3 of them backed out, so the 4th got it.
Yes.
But what was the, suppose it was a full-fledged mediation process or settlement process.
Yes.
So could the committee have gone below that amount, which is specified in the tender terms, in the advertisement?
No,
that minimum is, say, rupees 100. So could by negotiation be the tender be awarded at rupees 95?
No.
Then what was the purpose?
No, that, my lord, all the other parties, my lord, they had submitted their bid just at the price mentioned in the tender. Because the tender said that anything below the tender price, my lord, that will not be accepted. So everything they did, they were at the minimum price which was indicated in the tender. My price was just 1 rupee more than them. So my submission has been that they have taken a very technical view of the matter. In the words of the Honorable Court, my lord, in this decision, it's a myopic view, my lord, which is against the competition, which goes against the spirit of the competition, fair competition. This next paragraph is, my lord, 47, my lord. There, in the same page, we find support for our opinion. Has your lordship got it, my lord? We find support for our opinion from the Supreme Court judgment in Reliance Energy versus so-and-so, wherein the court has stated the following. We find merit in the civil appeal. Standards applied by courts in judicial review must be justified by constitutional principles which govern proper exercise of public power in democracy. Article 14 of the Constitution embodies the principle of non-discrimination. However, it is not a fair standing provision. It has to be read in conjunction with the rights conferred by others like Articles 21 of the Constitution. The said Constitution bench of 9 judges in I.R. Coelho versus so-and-so has held that they cover various aspects of life. Level playing field is an important concept while construing Article 19(1)(g) of the Constitution. It is this doctrine which is invoked in REL so-and-so. When Article 19(1)(g) confers fundamental right to carry on business to a company, it is entitled to invoke the said doctrine of level playing field. We must clarify that this doctrine is, however, subject to public interest. In the world of globalization, competition is an important factor to be kept in mind. The doctrine of level playing field is an important doctrine which is embodied in Article so-and-so. This is because the said doctrine provides space within which equally placed competitors are allowed to bid so as to subserve the larger public interest. Globalization, in essence, is liberalization of trade. Today, India has dismantled license Raj. The economic reforms introduced after 1992 have brought in the concept of globalization. Decisions or acts which result in unequal and discriminatory treatment would violate the doctrine of level playing field, embodied in Article 19(1)(g). Time has come, therefore, to say that Article 14, which refers to the principle of equality, should not be read as a standalone item, but it should be read in conjunction with Article 21. Now, para 38 is also quoted here, my lord. When tenders are invited, the terms and conditions must indicate with legal certainty norms and benchmarks. The legal certainty is an important aspect of this rule of law. If there is vagueness or subjectivity in the said norms, it may result in unequal and discriminatory treatment. It may violate doctrine of level playing field. Here also, my lord, when the tenders were, when I raised the query with the respondent MEPGCL, my lord, regarding how they will assess the tender and all, there was no reply given to that. Although they had at initial point of time said that the clarification should be given, but thereafter they resigned from it. So by that conduct, my lord, they refused the application of the doctrine of level playing field in the matter.
Yes.
Next case, my lord, that I will be placing reliance on. Well, it's a division bench judgment of the Honorable Guwahati High Court. This is on a very short point, my lord. I place this, my lord, only for the. I place this only for the proposition, my lord. If in a writ jurisdiction, my lord, if the Honorable Single Judge has taken a view of the matter,
Yes.
If in the writ jurisdiction, Honorable Single Judge has taken a view of the matter, I'll be relying on paragraph 26, my lord.
Which one?
This is Tractor and Farm. No, this is AIR 2004 Guwahati 73. AIR 2004 Guwahati 73. Well, paragraph 26, my lord. That will be at page 17. Page 17 will be on the right, yes, lordship. While dealing with the present appeal, the paragraph starts with this. Has your lordship got it, my lord? Paragraph 26. Well, may I read it out to your lordship, my lord?
Yes.
Now, para 26, my lord, while dealing with the present appeal, one has to bear in mind that a writ appeal is really not a statutory appeal preferred against the judgment and order of an inferior court to a superior court. The appeal inter se in a high court from one court to another is really an appeal from one coordinate bench to another coordinate bench, and it is for this reason that a writ cannot be issued by one bench of high court to another bench of the high court, nor can even Supreme Court issue a writ to a high court. Thus, unlike in an appeal in general terms, writ appeal is an appeal on principle, and that is why, unlike an appeal, in ordinary sense, such as a criminal appeal, where the whole evidence on record is examined by the appellate court, what is really examined in a writ appeal is the legality and validity of the judgment and order of the Honorable Single Judge, and it can be set aside or should be set aside only when there is a patent error on the face of the record of the judgment is against the established or settled principles of law. If two, my lord, I am putting emphasis on this, my lord, if two views are possible and a view which is reasonable and logical that has been adopted by the single judge, the other view, howsoever appealing such a view may be to the division bench, it is the view adopted by the learned single judge which should normally be allowed to prevail. My lord, on the same line, my lord, there is also a judgment of the Honorable Supreme Court, my lord. I'll just place it and I will not read it out to your lordship. That is reported in 2016, 3 SCC 340. Here is it. Your lordship can only just mark the paragraph, that is paragraph 5. Paragraph 5 will be at page 341. Well, So to the same effect also, my lord, that is the judgment of the Honorable Supreme Court in the later judgment, that is 2016 3 SCC. Next, my lord, I will be placing 1959 SCC online, Supreme Court, page 16. 1959 SCC online, Supreme Court 16. Paragraph 15, my lord. My lord, this I am placing on the question because your lordship has raised a query to me, my lord, that in a case of this nature where the tenderer, the other successful tenderer has done some work, my lord, whether any equitable consideration is to be given to him or not. That is a question, my lord, I felt that it fell from your lordship, my lord. My lord, the answer lies in my lord, this paragraph. The principle that has been enunciated, my lord, is that if some equitable consideration has to be given to somebody, well, that must not be vitiated by some transaction which is otherwise impermissible or branded by illegality. The paragraph 15, the correct position of law, in our opinion, has your lordship got it, my lord?
Yes.
The correct position of law, position in law, in our opinion, is that what one has to see is whether the illegality goes so much to the root of the matter that the plaintiff cannot bring his action without relying upon the illegal transaction into which he had entered. If the illegality be trivial or venial, as stated by Wilston, and the plaintiff is not required to rest his case upon that illegality, then public policy demands that the defendant should not be allowed to take advantage of the position. A strict view, of course, must be taken of the plaintiff's conduct, and he should not be allowed to circumvent the illegality by resorting to some subterfuge or by misstating the fact. If, however, the matter is clear and the illegality is not required to be pleaded or proved as part of the cause of action and the plaintiff recanted before the illegal purpose was achieved, then unless it be of such gross nature as to outrage the conscience of the court, the plea of the defendant should be prevailed. Now here also, my lord, if the equitable consideration can be given my lord, if the successful tenderer is to be given some equitable consideration, my lord, in my respectful submission, his case will rest only on the transaction that has happened in the case. And if the transaction that has happened in the case is visited by illegality, my lord, he will not be entitled to get any equitable consideration on that count. The next case is 2022 12 SCC 321. আরেকটা আছে নাকি কোনটা ওইটা আগে দেবো নাকি ওটা আগে দিন হ্যাঁ my lord, 2012 SCC 321, my lord, I will be relying on paragraph 69, 70, 71 and 72. Well, the principle that was enunciated in Kedarnath Mutani's case, my lord, that has
once more the paragraphs.
Well, lord, it is 69, 70, 71 and 72. It starts from page 362. Para 69 it is at page 362. My lord, paragraph 69 is practically a quote from the previous judgment, my lord, that I will not read, my lord. Your lordship can straight see the paragraph 70. The principle that the courts will refuse to enforce an illegal agreement at the instance of a person who is himself a party to an illegality or fraud is expressed in the maxim in peri delicto poritor est conditio defendantis. But as stated in Anson's principle of English law of contracts, there are exceptional cases in which a man will be relieved of the consequences of an illegal contract into which he has entered, cases to which the maxim does not apply. They fall into three classes: where the illegal purpose has not yet been substantially carried into effect before it is sought to recover money paid or goods delivered in furtherance of it; B, where the plaintiff is not in peri delicto with the defendant; and C, where the plaintiff does not have to rely on the illegality to make out his claim. In Narayanambam, the court was considering a suit for specific performance which was registered on the ground that the agreement to sale was contrary to the provisions of the statute. Section 61 of the Land Reforms Act provided that no land for which occupancy was granted shall within 15 years of the order of the tribunal be transferred by sale, inter alia partition was permitted. Equally, a mortgage could be effected to secure a loan. Drawing support from the judgment of this court in Kedarnath, this court inter alia as follows. Now, paragraph 16 has been quoted therein. It could thus be seen, well, this has been elaborated in 16. It could thus be seen that this court has held that the correct position of law is that what one has to see is whether the illegality goes to so much to the root of the matter that the plaintiff cannot bring his action without relying upon the illegal transaction into which he had entered. Next, the paragraph 72, my Lord, may skip the first part. My Lord, your Lordship can kindly turn to page 364. There the quotation from paragraph 26 is there. Page 364, para 26. However, the ticklish question that arises in such a situation is, the decision of this court would weigh in side of which party? As held by Hidayatullah J in so-and-so, the question that would arise for consideration is as to whether the plaintiff can rest his claim without relying upon the illegal transaction, or as to whether the plaintiff can rest his claim on something else without relying on the legal transaction. Undisputedly, in the present case, well, thereafter the facts of that case was discussed. There is no other foundation for the claim of the plaintiff except the one based on the agreement to sell, which is hid by section so and so and so. In such a case, as observed by Taylor in his law of evidence, which has been approved by Gajendra Gadkari in so and so, although illegality is not pleaded by the defendant nor sought to be relied upon by him by of a defendant, yet the court itself, upon the illegality appearing upon the evidence, will take notice of it and will dismiss the action ex turpi causa non ortio actio. That is, no polluted hand shall touch the pure fountain of justice. Here also, my Lord, if your Lordship will kindly recollect, my Lord, the agreement, I mean the work order that was issued to them, my Lord, there was a clause that some post-award conditions were to be fulfilled. And those post-award conditions were, it is not clear on record whether those post-award conditions were at all fulfilled or not. On the contrary, my Lord, the affidavit by the MEPGCL indicates that the very next day, the award was on 15th, the very next day the work started. So therefore, my Lord, my humble and respectful submission is this, my Lord. Even if your Lordship would consider it from the angle of giving any equitable consideration to the case of the private respondent who might have done some work at the place, Lord, that will be at the risk of at the cost of the illegality, my Lord, that they have committed in the transaction. And moreover, my Lord, this they have done knowing fully well that there were orders, observations of the Honorable Court operating, that the ultimate result of the contract, ultimate result of the contract will be subject to the
There was no injunction.
There was no injunction, my Lord, but the observation of the Honorable Court twice. First, the observation was that the settlement will be subject to outcome when the settlement was not yet done. The second observation came that the execution of the contract will be subject to the outcome. And they knew it, knowing fully well, my Lord, they went ahead into the work. So this is also one of the factors, my Lord, I'll submit that your Lordships must take into account to consider whether at all any equitable relief can be given to them. The broad view of the matter indicates that the existence of the contract, coming into effect of the contract itself was marred by illegalities. And one important thing that your Lordship had indicated me other day, that one question will be of legitimate expectation. Now, what legitimate expectation would be available to me in a scenario of this kind? If your Lordship will remember that the last minute of the meeting which they had done, in that meeting, my Lord, they had said that the further course of action will be decided in future. Naturally, my Lord, my legitimate expectation arising in that point of time was that some consideration will come on my way and they will take a pragmatic view of the matter. That they have not done.
That is feasible, legitimate expectation.
Yes. That was there, my lord. That your lordship, I am grateful, my lord, it failed from your lordship's this aspect of the matter was to be looked into. And the next judgment, my lord, there is one last one judgment, my lord. That is 2007 volume 2 SCC page 230.
2007
volume 2 SCC page 230. And I will be placing reliance on paragraph 29. Lord, may I read 29 to your lordship, Lord? That will be at page 241.
This is for what proposition?
My lord, that is when there is a conflict between law and equity, my lord, then law.
It's very simple. Equity follows the law.
Yes, my lord, that's it. That is.
You don't need 20 pages for this.
My lord, it's my endeavor to put howsoever, I mean.
You see, Mr. Datta, the thing is like this. At the end of the argument, almost, this construction of a stadium
Yes.
is something specialized and involves a large works contract. Now, contractors to undertake that kind of work, as we have learned from the submissions made, are very few in the state of Meghalaya. So if 5 or 6 have made their bid, immediately there was no kind of ground or proof before the learned judge to immediately declare it as a cartel.
No, my lord,
Because, number 2, when it was publicly announced, public advertisement, it did not prevent others from making their offers.
No, my lord, if I can address your lordship on this, my lord, the opinion of the honorable
you have already addressed. These are the essential facts.
Yes. Now perhaps, my lord, the honorable single judge has taken this view because of the reason that
it might be his lordship's submission, but there is not enough evidence to establish that a cartel is operating.
No, my lord, yes, to that extent, my lord, there can be a view. But, my lord, the impelling facts were that all of these contractors, barring one, they were members of the same family. And in the settlement process, my lord, the father aunt saying that no, we withdraw ourselves.
Maybe, but to come to such a conclusion, you have to put those tenders in the box and examine them.
No, one important matter, my lord, perhaps I have also missed out. There is in the Department of Meghalaya, my lord, under the government of Meghalaya, there is a process how tender has to be withdrawn. It cannot be just withdrawn by just appearing before the tendering committee and saying that we are.
All right. Then.
So possibly, my lord, that was the factor which weighed with the honorable single judge to come to a conclusion that the withdrawal process is also not as is required to be done under the.
Now, thirdly, 4 of them made a bid of a particular amount.
Yes.
Exact amount. That is the minimum amount.
Yes.
Your client made 1 rupee more. All right. Now, the terms and conditions of the tender do not say that the tender committee will have liberty to hold an auction in such a case.
Yes, my lord. That is why I placed Datta Associates, my lord.
No, your terms and conditions. Now, suppose your client is 1 rupee more. Forget the amount. But then is not with them, not at par. Now, at par can be called. But suppose you are also called, what would have been the purpose? That you bid?
No, I could have.
Lower your bid?
I could have lowered my bid by 1 rupee.
Yes.
I could have lowered my bid by 1 rupee to match their price.
So the selection committee was kind of holding an auction, type of an auction. An auction is always more, 1, 2, 3, 4, 5. But here it would have been
1 rupee.
5, 4, 3, 2, 1. in that way? Were they permitted to do so? And if they were not, have they committed a grave illegality in just calling the 4 who made similar bids?
No, there, my lord, I relied on.
You can say that they have not acted fairly.
Yes.
And they have not acted, they have not appreciated a legitimate expectation which another tenderer would have had.
Yes.
But you cannot write off the whole process as something fraught with grave illegality and should be cancelled by the court.
No, my lord, here, my lord, in my respectful submission, my lord, illegality will be constituted by not by a singular incident, my lord. It will be a combination of 2, 3, 4 incidents, my lord, that will give rise to an opinion that yes, something illegal has been
That is
committed
true.
here.
There is substantial ground for this kind of a submission because all are quoting on the last day.
Yes.
How will you know the others bid? All same bid, 1, 2, 3, 4.
Yes.
All right. And you are also on the last day for submission of tender, 1 rupee more. So you know the bids of one another. Otherwise yours would not have been 1 rupee more.
Yes. No, there is also another aspect, my lord. The tender condition said that the bid validity will be for 90 days. And why that was prescribed? Because so that the tender, I mean the work is not allotted to somebody who is undervalued. The bid is not undervalued. So the bid validity was prescribed as a life of 90 days. Here is a case, my lord, where the tender was allotted much beyond the 90 days period was over. So therefore, my lord, I said it is not a singular instance, my lord, by which, my lord, it can be caught that no, this is a grave illegality and therefore I should strike it down. Rather, my lord, it's a combination of more than 3, 4 factors which have contributed and for which, my lord, the Honorable Single Judge has taken an opinion that this is certainly not a fair transaction. This is certainly not a treatment which is to be meted out to a prospective bidder. And the reason for formation of that cartelization, my lord, even if I say that, my lord, even if I for the moment agree that the finding of cartelization is not to be there, still, my lord, there are other factors like your lordships had called for the affidavits from them. My lord, 15th of February, the work order was issued. Some post-tender conditions were supposed to be completed, like obtaining certificates and permissions and etc. They say on affidavit that the work started on 16th. How could that be even possible?
That is all right. Legitimate expectation is all right.
So therefore,
they have not acted illegally, but neither they have acted reasonably or fairly in inviting you also to sit at the table.
My lord, therefore, my lord, if
that may be a plausible argument, but this cartel thing would have been successful when, suppose there is a cartel, it's a cartel of 5, say cartel of 5. All right. Now there is a cartel of 5 and there is no other.
No, my lord, I admit, my lord, as your lordship is suggesting, my lord, to come at a very strong opinion about cartel formation, perhaps some more evidence was...
No, not more evidence. This thing does not support it. Because suppose the minimum is 100. There is a cartel of 5. All right. Now what will the members of the cartel do? They will decide amongst themselves A, B, C, D, E. Now E should get it. All right. Now A will quote at 120, B will quote at 140, C will quote at 160, and D will quote at 180, E will quote at 200.
Well,
all right.
Well, that will be, in my limited understanding, my lord, that will be an...
Or reverse.
Yes.
E will quote at 120. Now, it is more than the minimum.
Yes.
But because of the cartel, the hands of the government will be tied.
Yes.
They have to choose E.
Yes.
So from 200, 180, 160, 140, 120, say he quotes at 140 E. He has to get it because there is nobody else. By cartel, they have blocked other competitors.
But here on the...
All right, but here it is the bare minimum that all of them have quoted. And if it is the bare minimum, what is the advantage? Suppose A gets the contract and it is a cartel. What is the loss to the government if there is a cartel?
Now, loss to the government will be, my lord, because...
Now, if by the cartel, a much higher tender amount was extracted from the government, by preventing others, there are no more. All are members of the cartel. A higher tender amount is extracted from the government. then you could have said that this is a cartel type transaction. I'm saying it as
Now, my lord, here I am trying to answer your lordship's query, my lord. In a case where the prices are common, my lord, let us assume for the moment that all prices are same. Everyone has quoted the same price. Now, how the tendering authority will select the best? Because ultimately it is a selection of the best, and price is not the sole criteria. Because that the tender documents have made it very clear
that you are coming to your next point.
Yes.
That whether your technical competence should have been evaluated.
Yeah, exactly. That is the point. And therefore, my lord, since the tender condition itself makes a room for this kind of an analysis, that if the price considerations are on equal footing, then how to select the best? Naturally, then they will have to fall back on the technical assessment of the matter. That they have not done. And it is exactly on this point that I start.
But how they were obliged to do it?
Lordship?
This technical bid
Yes.
is an eligibility bid.
Yes.
Or it carries kind of weight.
Yes, my lord, it is looking at the terms and conditions of the contract, my lord, it gives me an impression that first of all, it is an eligibility bid. If you qualify the threshold, then you go to the price consideration. But it remains as a relevant consideration till the time of the contract settlement. Why? Because if there is a tie on the price, then your inter se competitiveness or inter se quality in the technical qualification is to be looked into. That is inbuilt in the tender. And why I objected? Because even if you want to assess somebody on the technical aspects, there have to be some laid down criteria that I will assess you on these broad parameters. Now, in the tender condition, no parameters were at all indicated. The tenders only said that I need to file this document, I need to file that document, I need to qualify this certificate, qualify that certificate. But otherwise no parameters were indicated how technical competence will be assessed. That's why I submitted representation asking for them to furnish me the result. And that is why, my lord, the observations of the Honorable Supreme Court in the Datta Associates case becomes relevant. That if you do not specify the criteria on which you are going to assess the competitive merit, then it becomes a defect.
Yes.
That is my submission. And if your lordship permits me 2 minutes, my lord, I can show your lordship the procedure that the government of Meghalaya has prescribed for rolling back the tenders. How the tenders have to be withdrawn. In the appeal memo 36. In the appeal memo, it will be at page 217. Appeal brief of 36 of Writ Appeal 36 of 2024. Now here, my lord, these are actually downloaded from the web portal of the government of Meghalaya. Well, there is a online bid withdrawal process. Now in the online bid withdrawal process, my lord, everyone has to log into the system, identify themselves with the system through their tender number and other credential, and thereafter they have to formally click on withdrawal. That your lordship will get. 219, your lordship will get that. And after, if your lordship has found 219, my lord, the next relevant page will be 221, where one has to log in using their credentials. It will be in the Writ Appeal 36 of 2024. Basically, my lord, this system has been introduced by the government of India and it has been adopted by the government of Meghalaya as well. So here you have to enter into the system by putting the login credentials. Page 221 on the right hand corner, top right hand corner, your lordship will find the login ID and password. So there, in that way, you will have to enter there. You will have to identify your particular bid that is available as page 222. then you have to click certain information, why you are going to withdraw it or what is the cause. Then particular 223, page 223, the particular tender has to be selected, and thereafter the bid is withdrawn. And the last page will be 228. And page 228 will indicate that the bid has been withdrawn. So nothing of this sort was followed by them. Even if they were to withdraw their bid, my respectful submission is this, my lord, they ought to have fall back on the, the practice that is being followed. Instead, my lord, the minutes of the meeting will indicate that they assembled together and they decided, rather it is also one observation of the Honorable Single Judge, that the Honorable Single Judge, the tender committee had delegated the exercise to the bidders. It is the bidders who have selected themselves. It is not the tendering committee selecting a particular bidder. They have they have allowed the bidder to take a decision who will be the successful bidder. Bidders among themselves, they select that no, I will walk out, he will walk out, you select Mr. X. And the tender committee accepts it. So this is also an area, my lord, where the tender committee has deviated from the practice, where the selection process, the idea of selection process or the exercise of selection process is vested with the authority of the tender committee.
All right, Mr. Dotto, you have argued your client's case in the best possible way it could have been done. Nobody could have done it better.
No, my lord, I accept your lordship's words, my lord, but then there are always shortcomings, my lord, from which we learn.
What you can do, you can argue it in the best possible way, which you have done. You cannot improve the facts. You cannot improve. You cannot.
Only thing that, my lord, I can try to.
You cannot reduce the facts also.
Yes.
But whatever available at you, you have done the best that.
I'm grateful. I'm grateful. I can only try to apply the legal principles, my lord, which I think, my lord, can be made applicable to the facts.
Nobody could do it better than you have done.
I'm grateful, my lord.
Yes, you would like to make something?
Yes, already we have already gone through all this. Some of the very minute things I would like Lordship to record it. I'll just tell the page numbers of my writ appeal, and Lordship will record the paragraphs.
Sorry?
Lordship, I'll just point out some of the relevant lines, Lordship.
Yes.
So Lordship will mark the line.
You mentioned that in your notes.
Yes.
If you want to make some oral submissions, you can make very short.
Lordship, the whole case they have based on was there was no technical evaluation done. I'm again repeating it for the waiver of this one. Lordship, the whole petition and the whole prayer depended on that no the single judge, learned single judge was made to feel that there were no technical evaluation done. And that the date of technical evaluation, Lordship, was never mentioned in the writ petition.
Madam, please don't come to facts, because on reply, if there is something very
and just
any
now
facts which have taken you by surprise,
no,
you mentioned.
Lordship, now about the withdrawn one, that is withdrawing of a bidding one, not after the settlement, Lordship. That's not the way. That is the one thing. And then, Lordship, I have given a list of the judgment, although I wrote long back, which I relied on with all paragraphs and all, but it was a handwritten one. I think it's in Lordship's file. I have to put it long back when the argument started. The judgments which I would rely on.
We'll give you some time. You prepare a 2-page note.
I have already done my written arguments also. I'm ready.
Yes, with that you.
I'll just annex that, typed and annex it.
I will find it within 2-3 days.
Lordship. And that post-tender, those necessity, it is there, Lordship. My client, when he was given the work order, he had given in written the acceptance along with the labors which were registered by him under the Labour Department was there. And then after that also, according to the tender terms, first that for the labours, registered labour, there are 2 conditions. Once, when you submit your tender, you have to be you have to have registered labourers, which I had. And when it was given, the work order was given to me, I had given that work order, that labour registrations, Lordship, which I had done in 2018. And after work order, I had applied. I have also got within 1 week those labor things. And the work cannot start on the same day or the very first day of giving me contract. Yes, we went there, we visited. There, it was a hill, it was a highland. That construction could not have just started on the same day, Lordship. So many groundworks were there. That's why they said that the work had started. It meant a lot along with the construction.
It meant registration of your labor.
Lordship, I have.
That is work started.
Lordship.
Well, to that extent, my lord, there is no disclosure in any of the affidavits. My lord, if my
Because that one was not pointed out that time. This matter came only on the last occasion. Then I started searching. This is not in their writ petition. This is never their argument, Lordship. They have brought this on the last occasion when they argued.
What?
About this post-requirement of this labor's registration. So I could not.
Requisition. It was the query of the court that how much work you had done.
No, that is what they have said after
in
that.
the course of that,
Yes, they have said. Yes, they could not have done it.
That when work order was issued,
Yes.
when work commenced, what percentage of work
Lordship.
and what value.
Lordship.
And lastly, did you receive any payment for that
No,
work?
I did not receive any payment. Lordship, I had.
No more on facts. We know. We have gone through the
Yes,
facts.
I have labor registration. I have the certificate, everything.
Anyone else? You were 2 minutes, Mr. Pandey.
That withdrawn one won't affect our case, Lordship.
As far as the facts are concerned, I am not going to repeat any facts. The heart and soul of the matter, my lords, your lordship has already observed. As far as the issue of cartelization is concerned, that is, there is insufficient material to prove anything. And moreover, there is one important thing I may have just at the closing highlight, that one of the participants out of the four bidders who quoted the identical bids, one of the participants was not even made a party to the writ petition.
That you said.
So, not only all people were required for cartelization, one of the members who quoted the identical bid is not a party to these proceedings. So, there cannot be the writ petitioner in a way conceded that that individual reached to that figure independently by his own. So, the question of cartelization falls flat after that. When any person can independently reach that figure, which is the minimum quoted price, then there is no question of cartelization. That is.
So you are drawing that conclusion from he is not being made a party.
Yes, my lords. They have admitted that he is not part of the cartel.
Well, I'm sorry to interrupt, my lord. The reason was that we, in our writ petition, we also mentioned that we understood his price to be a higher price. If your lordship will kindly see this paragraph, my lord, at page 10, my lord, depending on the earnest money deposit, my lord, we understood that he quoted the highest price, highest among the all. That's why we did not make him a party. Page 10 of the, 76, not 10, page 76 of the appeal brief, my lord, the categorical statement was made.
What was his name, Mr. Pandey said? I noted it down.
Yes.
Mustafa Kharkhonga.
Mustafa
He was made in the writ petition. His statement was there that he was a same family member also, lordship. It has been observed in the judgment, which is not. And my learned friend is saying he was estimated.
No. How can that be judgment? He was not even made a party in the case. How can the observation come?
5 of them from the same.
Anyway.
What do you say? It is there in the judgment. It is observed in the judgment. He was from the same family.
My lord, your lordship will kindly allow me some time, as your lordship has indicated, to put up a note, my lord, within 2-3 days.
Mustafa
Kharkhonga. Oh, this was highlighted. Your lordship had already
written the meeting.
Yes, my lord.
Then
he was also there in the meeting.
Lordship,
Our understanding was that, well, the writ petition was filed. Our understanding was that
understanding was wrong.
Yes.
that was wrong.
You were not called for the meeting because you were 1 rupee more.
Yes.
So Mustafa was called. Certainly, he was at par with them.
But our understanding was that, my lord, he was the highest bidder. Our understanding was that Mustafa had quoted price even higher than me. That was the averment.
You see, it's at least to me this is not very important.
Yes.
Because once you allege cartel, all right. Now, when you say cartel, and cancellation of the contract, the underlying ground should be that you have caused loss to the government.
Yes.
By forming a cartel and bidding in that way.
Well, here also loss will occur. If a less competent person has gone because of this, my lord, if the less competent person has backed the contract, my lord, that will be a loss to the government.
No,
that will be a loss to the...
Wow, it's an open competition, open advertisement.
No, my lord,
where is the other offer?
No, my lord, if the person who has been selected for the contract, if he is technically low, in that case it will be injurious to public interest, my lord.
It would have been injurious if all of them had kind of gagged the price up.
Yes.
And one of them got it at a extraordinary price.
Yes.
Not normal price. Then you say that yes, the kind of subverting the tender process by cartel.
My lord, even if I give up the point of cartelization, my lord, I am not pressing...
Your other points are there, Mr. Dotto. Your other points are there.
Just one more point, my lords. One more point, and then I'll finish. That as far as, my lords, the aspect of construction of works is concerned, because a lot of emphasis was put on that fact, none of the parties before your lordships have doubted that the construction has started at the site. The writ petitioners, in fact, moved a contempt petition, and I have photographs at page.
That is part of the writ petition
Yes,
itself.
at page 129 of my writ appeal paper book. The photographs are there.
Was there an order of injunction restraining construction?
No, my
No.
lords.
Only thing is that it will be subject to outcome of the writ proceeding. Award of contract subject to execution of work subject to outcome of the writ proceeding.
Passed by the appeal court.
No, the single judge, honorable single judge. And in the appeal, Miller, it was said that it will be at the risk and cost of the contractor. In the appeal proceeding, Miller, there was an observation by the honorable division bench that it will be at the risk and cost of the contractor.
So there was
Then it stopped.
Thereafter, it stopped.
No, Lordship, when the single judge order was passed, immediately on that day it was stopped. Not during the time of filing writ appeal.
No. The affidavit says otherwise, my lord. Affidavit says that it was stopped later.
No, when the single judge's order was passed.
Single judge's initial order was during...
No, the final order I'm saying. I'm not saying about the initial order.
No, my lord, he is asking for the initial order of the injunction, or I mean the observation, my lord.
After the final order was passed, Lordship, judgment and order dated
My lord,
7/6/24, Lordship. After this, we stop. How can we carry on work after this?
my lord, the first order of the honorable single judge on 27th February, and the second order was on
Which year?
2024. 27th February 2024 was the first order.
What was the first order?
First order was that settlement of the contract will be subject to outcome of these proceedings, because they said, I mean, the projection from the government side was that the settlement was not yet done. So the observation of the honorable single judge was that settlement will be subject to outcome. Now, when later it transpired that already settlement was made, then the observation came that any further work will be, that was on 10th of April 2024, any further work will be subject to the orders of this court.
10th of?
April 2024. Because as my learned friend has said that, my lord, it was us who brought it to the notice of the honorable court that the construction they have commenced. And thereafter this observation was made.
Well, what was the order?
It is made clear that any further work will be subject to the orders of this court. Well, Mr. So-and-so submits that the work has since commenced. It is made clear that if the submission is correct, any further work will be subject to the orders of this court. That was on 10th of April. And according to the affidavit filed by the MEPGCL, the work stopped on 7th of June 2024.
Yes, when the final order was, when the court said that it will depend on the outcome of the case, we immediately stopped it on the day of the judgment. We were asked to stop.
So that was 10th April.
7/6/24 was the final judgment.
They continued after 10/4. They stopped it on 7th June
Because
after
there was no
the judgment was passed.
Yes, Lordship, there was no.
This is an interim order.
No,
Yes, these are interim observations passed in the court, my lord.
That's not interim observation. Do not. Lordship,
My lord,
observation by the
my lord,
court.
what expression shall I use for this, my lord? I am reading out an order of the court. My learned friend is saying that it is
It's
not.
an interim order, that's all.
And my lords, I may just point out, by order dated 12th of July 2024, this honorable court in writ appeal
Yes.
ordered that let the successful bidder continue with the work. However, he have to take the risk of the result of the writ appeal pending before this court.
This is the appeal court.
Appeal
This is
court.
the appellate
my lords.
court.
This
Dated?
honorable court. This is an order dated 12th of July 2024.
Still, we did not work, Lordship. My materials got wasted also.
And
A learned single judge, 7 June 2024.
Yes, my lords.
7 June 2024 judgment was delivered.
And there also they said that the work will.
No, then the, my lord, the work order was set aside.
Work was set aside.
Work order was set aside.
The learned single judge said that everything will be subject to outcome of the case. So no interim injunctions were passed. Everything is based upon the outcome of the proceedings before this
No,
honorable.
in the final order also, His Lordship said the same thing.
No, final order it was set aside. Thereafter, the matter came to this honorable court in writ
Final
appeal.
order, the honorable court said the work order is set aside.
Set aside.
Work order dated so and so is set aside.
And we immediately stopped working.
And in the affidavit, my lord, my learned friend shows that they purchased materials after the judgment is
Yes.
delivered.
We have to order those materials prior. This state of Meghalaya. It has to come from outside.
Then, according to you, when the contract was entered into?
Lordship, 15,
February.
24. Am I wrong?
Where they say we accept your offer, but subject to those, you're fulfilling A, B, C, D, as Mr. Dotto said that was no contract at all.
No.
Because no, there was an agreement, there was a clause for signing the agreement. They did not sign any agreement.
Lordship, it is between the owner
All right.
and the subject. The other person cannot come in, Lordship. Whatever the owner of the tender.
All right,
also, he
15th,
can do.
15th February.
Yes, Lordship.
15th February 2024, Your Lordship. The work order.
The one important thing I mentioned here, Lordship, what happens now? Technical evaluation, he is there, he signs on the attendance sheet. Then the financial bid is there, he signs on this one. After that, when he knew that he was not the lowest bidder, then he started writing representation.
No.
Yes, Lordship, I have stated.
My lord, I have closed my brief, my lord. I cannot keep on answering to her.
Lordship, I have in my affidavit stated very plainly, they even got the non-trial delays had to come and persuade the department to give the work to them.
And 27th February, the order is subject to settlement of contract.
Yes, because that was the motion day, my lord. The projection from the MEPGCL was made that the contract was yet to be settled. That's why the honorable single judge observed that the settlement of the contract, if any, will be subject to the outcome of further orders of the honorable court. Because the formalities were yet to be finished. That was the projection made on that day.
But I have papers which shows.
These papers ought to have been shown before the honorable single judge. You sat tight, thinking that your masters will take care of you.
Because the whole petition was bogus. And I can tell you that immediately.
Lastly, my lords, these 2 points I've already made. Last point is, my lords, I have just quoted in my synopsis a recent judgment of the Supreme Court in 2023 in the case of Tata Motors.
No, you cited. They should also know.
Yes, I have cited the same judgment. This is part of my petition. I'm just supplying a copy, my lords. Just supplying a copy for your
Brihan
lordships.
Mumbai Electric Supply, yes.
I've also given.
This is a judgment which I've already shared it previously also, my lords. I'm just sharing a copy for your lordship's convenience.
What is the citation?
My lords, this is 2023. 2023 SCC online SC671. And I am relying, my lords, I am not reading, my lords, paragraph 47 to 51 lay down the entire law as far as interference in my lord's tender jurisdiction is concerned. Specifically, my lords may take notice of paragraph 50.
50.
50. 50, my lords, middle of the paragraph. To set at naught the entire tender process at a stage when the contract is well underway would not be in public interest. Initiating fresh tender process at this stage may consume a lot of time and loss to the public exchequer.
Yes. Up to end.
Yes.
50 to end.
Yes.
All right.
Yes.
Please take down. Hearing concluded. Stop CAV. Advocates on record for the parties are at liberty to file written submissions with the master attached to this court by 28th August.
Yes, ma'am.
Wait. Obliged.
Obliged.
Any other matter? Thank you very much, all of you.
I am greatly grateful, Mel.